Hello everybody and welcome to our today's webinar, which is held by us of Dompatent in cooperation with lawyers from the law firm Taylor Wessing. I would like to start with a short introductory comments. We will record this webinar and will afterwards, of course, send you the video. And as a second side note, the microphones will be muted now or closed, and we will open them at the end of the webinar for your questions. And if you have questions during the webinar, please do not hesitate to write them in the chat, which should be open, and I hope it works all right. And we will answer these questions then in the end. Yeah, after this more technical introduction, I would like to open the webinar with the topic the UPC celebrates its first birthday, first impressions and experiences. And we are very happy to have two guests here today, namely Mr. Roland Küppers and Mr. Christian Deknonick from the law firm Taylor Wessing. They are both lawyers and partners at Taylor Wessing, and as UPC representatives represent clients at the UPC. And yeah, in the first year of the UPC, they got already experiences and of course impressions there. We are quite happy to have them here today.
Thank you very much.
But before we start with these really interesting facts, I would like to give a short introduction on the UPC itself. Yes, it's working perfect. As you know, since it's the first birthday party now, the unitary patent system started 1 year ago, on 1st of June 2023. And the system consists basically of the so-called unitary patent, which is a granted European patent, which is valid in several countries which are participating in this unitary patent system. And the second pillar, which is of course quite important and the main topic today, is the Unified Patent Court, the UPC. Maybe some first background about the scope of the unitary patent. In general, 24 EU member states, member states of the European Union, have signed the so-called agreement on a unified patent court, the UPC agreement, which means that the unitary patents could in principle be valid in 24 member states, but so far, the unitary patent is only valid in 17 of these countries. They are shown here in dark blue. Maybe as an interesting fact, you may have heard about it already. Romania has now ratified this UPC agreement, and it will enter into force on 1st of September 2024, which means that after this, or on 1st of September, we will have 18 countries which will participate in this system, which is quite nice to see that it's already expanding. For the court, the Unitary Patent Court, of course it is a supranational court of the European Union, and then it makes sense, or it is not that new, maybe, that it has several divisions in different countries. For example, local divisions, so-called local divisions. In Germany we have, for example, Munich division and Düsseldorf. We have 4 here in Germany, but there's also Brussels, The Hague, or Lisbon. You can see them here in green on this small map. There's also a so-called regional division. This is for, or several countries are participating in this. They decided not to have their own local division, but to work together on this. And really important also are the so-called central divisions, which are here in yellow, in Munich, Paris and Milan. Milan actually was confirmed today, or started today, was confirmed a little bit earlier. It was maybe a side fact. It was first thought to have this third central division in London, but as you all know, after Brexit, this was not possible anymore. Then it was decided to have it in Italy and Milan, but this is why this central division started just now and not like the other ones last year. As always, we have not just the Court of First Instance, but also a Court of Appeal. This is situated in Luxembourg. This is just maybe basically the same information in another slide. You can see that Court of First Instance, and the Court of Appeal in Luxembourg. And also interesting to know, probably, also the Court of Justice of the European Union may be involved in the UPC system, because both the Court of Appeal and also the Court of First Instance, so all the divisions which are there, may file requests on preliminary rulings on questions of EU law with the highest instance of the European Union. And with this short overview, I would like to close my part in this. This is just about the procedure at the UPC. As you can see here, it's divided in a written procedure, then the so-called interim procedure, and an oral hearing. And what is maybe really interesting to know is that the time schedule is quite tight. For example, you have, after the action is served, 3 months to file a statement of defense, and also to a revocation counterclaim if you would like to attack the patent which was used in the action. So this is to be done within 3 months, which is a tight schedule. And as I have now learned from the colleagues here, that if the court sets a period of time, they are quite reluctant to grant you extensions of this. Yes, with this short overview, I would like to hand over. Thank you again for joining us here, and now our two guests will talk about their 1-year practical experience at the UPC.
Thank you very much, Annika Meyers, and thank you for joining our webinar today. Indeed, my colleague Christian Deknonick and myself would like to introduce you to some of the, let's say, first practical impacts and impressions that we had with cases in the UPC. First of all, we would like to introduce you to some statistics on the court system, the caseload after 1 year. It is quite impressive, as we will see. We will also talk about claim construction, which is the center point for every case, be it infringement discussion, be it validity issues. It all centers around the claim construction of the patent. Then we have some practical comments and decisions on the allocation of technically qualified judges. And last but not least, we will also talk about the language of the proceedings, which has been always an issue during the discussion before this court entered into force last year. So let's look at the statistics. By the way, this is a picture of indeed the court of appeal in Luxembourg. It is the former building of the European Council. Here we have the pending UPC proceedings. The source for the statistics is officially taken from the UPC website. And what you can see is in this last year, the caseload has impressively taken up 134 infringement cases. What you should see here on this slide as well is that 71 of these cases are infringement cases only, and 63 of these infringement cases include counterclaims for revocation. It seems, unfortunately, that this is not displayed correctly here on the screen, but what you cannot read in this blue rectangular is that there are 165 counterclaims for revocation filed in total. Please don't get irritated by this number. They have not been taken into account in this round diagram because you have to file counterclaims for revocation individually. That means if you have co-defendant in infringement cases, each of them has to file a separate counterclaim for revocation. This is why this number is high and not reflecting the correct allocation to the actual case number in infringement cases. So what you have in addition are 39 cases for revocation, separate from any infringement, maybe parallel, maybe not, to an infringement case. And interesting here as well at the moment, and unfortunately it's not displayed here, it's the number of applications for provisional measures. It's the purple share of this diagram, and it should say 27 cases are filed for applications to grant provisional measures. And another 5 cases have been filed applications for preserving evidence. So it seems that in the first year, a number of patentees used the UPC system for speedy proceedings like obtaining preliminary injunctions or preserving evidence. And those are also the decisions which we have seen by now, and we will talk about them a little bit later in this presentation. On the next slide, you can see the distribution of these proceedings without the revocation cases. So most of the infringement cases, as well as requests for provisional measures, seem to go to the 4 German local divisions. As mentioned by Annika Meyers, we have the Munich local division, which is clearly leading in this statistic, followed by Düsseldorf, Mannheim, and Hamburg. And furthermore, we have the Paris local division, Milan local division again, The Hague, and so on and so forth. And of course Brussels, not to mention that, not to leave out Brussels, where my colleague Germany and Christian Deknonick is coming from. So the tendency of patentees clearly show that they start proceedings in the German local divisions at the moment. Of course, as we discussed before this court system took up in the German local divisions, there's a relatively high predictability, as we thought, because we have always 2 German legal judges, which is accompanied by 1 international judge from the pool of judges, which is probably a little bit different from most of the other local divisions.
But I may say that we expect that in other local divisions, cases will also grow now that we get more and more uniform case law. So,
I'm sorry about that. Okay.
Yes. So I expect that in the lower region, let's say Helsinki, Copenhagen, etc., there will be also cases being filed as the case law gets more and more uniformized.
Yeah, this is also combined with the language issue, which this statistic here shows. Currently, 50% of the proceedings are led in English as a procedural language, and German 44%. In fact, in the recent months, the procedural language of English has increased, while only a few proceedings are led in French, Italian, or in the Dutch language. Of course, all the local divisions as well as the regional division have implemented English as at least a second procedural language for the proceedings, and it seems that patentees use English widely throughout the system as procedural language. Christian, you will talk about the language choice and decisions a little bit later. We will turn to claim construction first of all. As I said, it's a center point for each and every case, and the most relevant case in this respect has been rendered in proceedings for preliminary measures or provisional measures. Nanostring and genomics is the name of the parties, and the guidelines were here defined by the Court of Appeal, which starts, not surprisingly, from Article 69 of the European Patent Convention in conjunction with the protocol on the interpretation of this article. And it says, of course, that the interpretation of the claim must be based on the claim wording. The description and drawings must always be taken into account as explanatory aids for the interpretation. And the patent claim is not only used as a guideline, but it must also be interpreted in such a way that it reflects the overall understanding of the person skilled in the art. And when applying these general principles, the appropriate protection for the patent proprietor or the patentee should be combined, of course, with the legal certainty of the third parties. So these, I think, at least from the German perspective, are the typical and usual principles for claim construction. In fact, at least from the national perspective, we have not yet been taken by surprise in this new court system. And as I mentioned, the principles for claim construction are used for both the assessment of infringement and for assessing any validity issues of the asserted patent. So some further decisions have been rendered. One of them was here rendered by the Court of Appeal, again in proceedings for provisional measures, in the case called Wuschen Group and Henshaw. This was a little bit later than the nanostring decision, and it confirmed exactly the same principles, but it added that each feature of the patent claim to be interpreted must be read in the light of the claim as a whole. So it's the overall understanding of the skilled person, which again would be in line with what we already know from national proceedings, but to have this confirmation here at this early point in time from the UPC, especially here from the Court of Appeal, is quite useful. There are furthermore some decisions from the local divisions that we have put on the slide on side aspects, important side aspects for the claim construction. One is related here from the Düsseldorf local division on the purpose statements, which we regularly find in claim language, especially for method claims, as well as for device claims. They usually serve to improve the understanding of the invention. So you cannot just leave them aside. You must interpret them, you must take them into account, and they may have influence on the special and physical characteristics of a device claim, for example, so that such a device with these physical characteristics is usable to fulfill the purpose stated in the claim. More restrictive elements can come into play from these purpose statements when, for example, a physical feature would not be able to fulfill a specific function. This would be a physical restriction, and also you have to take into account that the purpose statement can have a temporal restriction, for example, where you have a method which is described in the claim as a sequence of process steps. And again, here the purpose statement can have influence on the order of the process steps, and maybe even on the time component and the temporal component, which is playing a role to achieve the success of this invention. And last but not least, we also refer to this decision from the Vienna local division, quite an early one from September last year already, again in proceedings for provisional measures. It already showed a consistency with the later decision in nanostring, and it also includes a hint to numerical and dimensional data, so a range of data like 0.5 to 2 meters, which is claimed, either further described then in the description or further laid out in the subclaims. And the Vienna local division applied the skilled person's perspective that minor deviations could generally be covered by a specified range of numerical data, but it was not here in the case which had been decided in Vienna. An interesting topic that has arisen in the UPC and which is discussed in a different way throughout the national European court systems is whether you can take into account the prosecution history or the file history of the patent as interpretation material for claim construction. We have the decision here from the local division in Düsseldorf saying that Article 69 is conclusive, and at most such prosecution history, for example, statements of the patentee, can have indicative significance. And a little bit further was the decision from Munich in the former SES or later Vusion Group and Hanschel case, where original claims were filed with the patent application and they were taken into account in the context of amendments of the claims by way of indication for the claim construction. So that means the original claims were used as indication how to interpret the later amended claim language. At least for confirmation purposes, the Munich court used this prosecution history material, but this had not been confirmed yet by later decisions of the Court of Appeal. I jump to the last decision here on this slide, where you can see in this case that the Court of Appeal has not found itself in the position to address this question. It was simply not needed in the case. The claim construction was purely made on the basis of Article 69 and the claim construction principles, and therefore it has not yet been decided whether file history can be taken into account and to what extent this could be. So for everybody using the UPC system, that may be another chance to develop the case law in this respect. Well, with this I would leave the current situation and decisions on claim construction and go to the allocation of technically qualified judges. Just as a matter of principle, the local divisions as well as the regional divisions are composed of 3 legal judges, legally qualified judges, and they can request for the allocation of an additional technically qualified judge, either upon the request of one of the parties. This can be done, or upon the court's own initiative after hearing the parties, as laid out in the rules 33 and 34 of the rules of procedure. Interestingly, for the request by the parties, it is mentioned in the rules already that this request must be filed as early as possible in the written procedure. It was a bit unclear yet at the beginning of the court taking first decisions whether the court's own initiative has to be done in a very early stage of the proceedings, and whether such request coming from the court would be allowed for preliminary injunction proceedings or proceedings for provisional measures. If such a request is filed, then a technically qualified judge is allocated by the President of the Court of First Instance from the pool of judges. And of course, the technically qualified judge should have the qualification and experience in the relevant technology, which means in the cases we have seen that there is a general experience in this technology, but no specialization, which is of course not possible with a limited number of technically trained judges available. A very recent decision from the Düsseldorf local division now confirmed for proceedings on the merits that the court's own initiative should be taken when the counterclaim for revocation is filed, which is usually together with the statement of defense, which is quite early. It was clarifying because in the rules it seems that such a request from the court's perspective would be filed after the interim hearing, and that is a very late stage of the proceedings, only allowing a few weeks or months before the hearing. And I think from a practical point of view this would be simply too late for a division to prepare the case together with a technically qualified judge in such a short period of time only. And therefore the courts have a clear tendency to request for additional technically qualified judges at a very early stage of the proceedings. In particular, it has been, in practice, it has been applied also in proceedings for provisional measures, although this is again not explicitly mentioned, where the same technical issues can arise. For example, when the asserted patent is complex, or the validity of the asserted patent is at issue or will be at issue. Because the court has shown here that they are even prepared to ask for a technically qualified judge before the defendants file their objection in such proceedings. So even before they know whether there will be validity issues to be discussed, they have a tendency at least to have a technically qualified judge allocated to the proceedings to get to prepare the case together with him and to make the further arrangements together with this technically qualified judge if necessary later on. There are decisions taken on the question of the allocation of technically qualified judges. One is here from the Düsseldorf local division in genomics and curio. And it confirms that also in the expedited proceedings, which are proceedings for provisional measures, such a technical judge should be involved on the own initiative of the court. And the reason is also nicely pointed out here in this decision, because this technical judge in this case can familiarize himself with the case at an early stage and can therefore advise the judge rapporteur at any time if necessary. And as already mentioned, it is also necessary to coordinate with a technically qualified judge early in the proceedings. Last but not least, I would like also to mention another decision from the Düsseldorf local division saying more or less the same, again in proceedings for provisional measures. And here in this case, the respondents or defendants also had dealt extensively with the legal status of the patent in dispute. And therefore it was of course indicated from the court's perspective to involve a technically qualified judge. As a whole, from our experience in the cases we have seen, the local divisions and the regional division have usually requested for the allocation of a technically qualified judge. I think this is a good signal also for patentees that the necessary technical input can be given from a scientist's point of view during the proceedings, and it is a practical implication that this technically qualified judge is allocated as early as possible to the case. And with this, I think you have further comments on technically qualified judges, Christian.
Yes, I wanted to highlight one case of the Court of Appeal in relation to the role of technically qualified judges, because I totally agree with what you said, Roland. It seems good that technically qualified judges are involved as soon as possible in any case before the UPC, and therefore this recent decision of the Court of Appeal was interesting. You may know this Ocado decision in relation to transparency. It has received some publicity in this regard, as this decision confirms that, as a rule, documents filed with the UPC are publicly available unless there are some confidentiality issues. So that was a good decision, I think. But this decision also had some, there was also a part on the role of the technically qualified judges and on Article 9 of the UPC agreement. And Article 9 relates to the composition of the Court of Appeal, and in the first paragraph of Article 9, it's clearly stated that any panel of the Court of Appeal will consist of, on one hand, 3 legally qualified judges, and on the other hand, 2 technically qualified judges. And paragraph 2 of that same Article 9 provides for some exceptions, specifically mentioned exceptions. However, in the first decisions of the Court of Appeal related to non-technical issues, we have seen that the Court of Appeal consisted only of the 3 legally qualified judges, not without the technically qualified judges. And this has raised some questions. And in this case, one of the parties raised the argument that this was contrary to Article 9 and therefore also contrary to Article 6 of the European Convention on Human Rights, which provides that a court shall be established by law, which also relates to the composition of that court. But the Court of Appeal did not agree with this interpretation and clearly stated that the provisions of Article 9 are not exhaustive in relation to the composition of the court, and it does not preclude that the court can consist of only 3 legally qualified judges in cases where only matters of non-technical nature are in dispute. And they refer to the wording of Article 9 of the UPC agreement, the systematics of that agreement, and to the rules of procedure. In view of Article 9 and the wording of the first paragraph, it could have been decided otherwise, in my opinion, and it seems to indicate that, according to the Court of Appeal, the role of the technically qualified judges is merely to advise the legally qualified judges on the technical issues at hand, and in my opinion could have decided otherwise, in the sense that the input of the technically qualified judges on non-technical matters may also be relevant. And a nice example thereof is on, for instance, change of language of the proceedings, the next topic. One of the factors to be taken into account, as we will see, is the language of the prior art at hand. In that sense, it would be, in my opinion, it could be interesting to see or to hear what the technically qualified judges have to say on that point. Nevertheless, the Court of Appeal has decided in this way. It could still end up, in view of the importance of the argument, before the Court of Justice, but that remains to be seen. So, next topic that has raised some case law of the UPC is the language of the proceedings. Maybe as a reminder first, as explained at the beginning of our presentation, in the local divisions, several local divisions, cases can be initiated in either language of that court, so each local division has designated languages, and Article 49 provides that apart from the national languages on the one hand, the local divisions can indicate also another language as language of the proceedings, being one of the official languages of the EPO, French, German, or English. And we have noted, as clear from the statistics, all local divisions of the UPC up to now have designated English as the language of the proceedings. So it's in all local divisions possible to initiate a case in English. And in the regional division of the Nordic Baltics, it's even the only language in which you can initiate a case. So it's not possible to start a case in Lithuanian, for example. You have to start a case in English in that local and regional division. The other extreme is the Brussels local division, where you can start proceedings in the three national languages of Belgium, Dutch, French, or German, as well as English. So there you have a choice between 4 languages. Now, Article 49 provides that if a case has been initiated in a certain language before a local division, that under certain conditions the language can be changed to the language in which the patent was granted. For instance, a case is started in a German local division based on a patent granted in French. You have to start in either German or English, but the claimant or the defendant can ask to change the language of the proceedings to French, being the language in which the patent was granted. And this choice has given rise to some case law. There are 3 possibilities. Either both parties agree and ask the panel to change the language of the proceedings. If the panel does not agree, then the case will be referred to the central division. Either the panel suggests to change the language of the proceedings, and if both parties agree, language will be changed, or either one of the parties, claimant or defendant, requests the change of the language, and then it's up to the President of the Court of First Instance, after having heard all parties in the case, to decide on this request to change. And Rule 323 of the Rules of Procedures provides that this change of language can be requested by the claimant in the statement of claim, in the first document that is provided, and by the defendant in the statement of defense. And this is the first issue that has raised on procedural fact. In this case that is discussed here is the Hague case of Arkheim versus Plant E. In that case, Plant E is a Dutch, 2 Dutch companies had started infringement proceedings before the Dutch local division, the Hague local division, in Dutch, whereas the patent was granted in English, and the case was started against a Spanish company. And that Spanish company filed immediately an application to change the language of the proceedings, not in its statement of defense, as seemingly provided for in Rule 323 of the Rules of Procedures, but in a generic application. And the question was whether such application was admissible and whether or not they should have waited until the statement of defense. Luckily, I think the President of the Court of First Instance considered this application admissible. It would have been strange indeed that you have to wait until the statement of defense, that you have to write in the first language to ask the change into another language. And the Rules of Procedure, the President of the Court of First Instance, Ms. Florence Butin, argued this is the deadline, and you can ask it for at the latest in your statement of defense. So that's a first procedural issue that was considered in this decision. And on the other hand, in this case, the President considered, after having heard both parties and the panel of the local division, that indeed the case should be, that the language of the case should be changed to English because, and I quote, the language initially chosen is significantly detrimental to the applicant being Arkheim, the defendant in the infringement proceedings. Indeed, it was considered detrimental for a Spanish company to have proceedings in Dutch, whereas the patent at stake was written in English. And this significantly detrimental test has been applied in some other cases by the President of the Court of First Instance, but then in all those cases the President refused the change of language. In the Düsseldorf case, genomics that was already discussed in a decision of the 26th of February 2024, this application to change the language of proceedings, PI proceedings, brought in German, whereas a patent was granted in English, was refused as no particular circumstances were put forward which would have an impact on the fairness of the case. So the bar was quite high. Same in the Paris case, where infringement proceedings were brought in French, whereas the patent was granted in English. And there the President argued that neither the nationality of the representative or of the intervening parties justified any change of the language. French was okay. And finally, in the Mannheim court decision of 15 April 24, once again, the change of language was refused. The proceedings were brought in German, whereas the patent had been granted in English. Once again, the applicant for the change of language did not provide any arguments according to which it appeared that there was some obvious affection of its possibility to make its defense, to prepare its defense. The Court of Appeal had to decide on one of these cases, in the genomics case, and in that case, the Court of Appeal set aside the decision of the President of the Court of First Instance, and I quote, "because it is based on an incorrect reading of what constitutes fairness and what circumstances are relevant under Article 49(5) of the UPC agreement." And the Court of Appeal clearly considered that the significantly detrimental test, that the bar was too high, and that other factors should be taken into account. And the relevant circumstances relating in theory, in essence, to the specifics of the case and the position of the parties. And with regard to the specific case circumstances, let me call it, two examples are given by the Court of Appeal. The language mostly used in the relevant field of technology, as well as the language of the evidence. If all documents, exhibits provided by the claimant are in English, but nevertheless that party insists on proceedings into German, that's one of the issues that could be in favor of a change of language. Circumstances related to the parties include the nationality of the parties, where they are domiciled. Indeed, it's important for the Court of Appeal that the parties, not the representatives, the party must be fully able to understand what is submitted either by their own representative, either by the other parties. Another circumstance that was included by the Court of Appeal in its decision was the size of both companies. The fact that Curio Bioscience was smaller than Genomics was one of the elements taken into account, as well as the delay that may be caused by this change of language. Interestingly, the Court of Appeal also noted some circumstances which were not relevant, being the language skills of the representatives. That was one of the arguments by one of the parties in this case. Not relevant. The language skills of the parties, yes, but representatives not taken into account. Neither the nationality or language skills of the judges. However, when we discussed this slide prior to our presentation, Roland mentioned that in proceedings before the Court of Appeal, it was asked, despite the fact that the language of the proceedings was German, to have the proceedings in English, the pleadings in English, to allow all courts of the panel hearing the case to directly understand the position of both parties, of all parties present. despite the fact, therefore, that the language of the proceedings was German. And finally, the Court of Appeal argued or decided that if all circumstances are equal, it is the position of the defendant that is decisive. So in view of all these circumstances, in this case, the Court of Appeal decided to set aside the first instance decision and change the language of the proceedings into English. So in view of this Court of Appeal decision, it's clear that the bar is a bit lower to change the language of the proceedings. The bar is set quite high in first instance, and that in view of the fact that most European patents are granted into English, it will logically follow, I think, that most of the proceedings will be held in English, and that was already clear from one of our first slides in relation to the language of the proceedings, which already showed that more than 50%, I think, of the cases, 50% of the cases were in English. That was our last slide, I think. Yes. So.
Yeah, I'm back in now. Thank you very much for this great overview, and I think the topics were, really interesting. The language, the technically qualified judge. Thank you very much again. I think we might have some questions in this regard. I'm not sure whether we have some in the chat, but we will also open the microphones now. So if you have any questions, please feel free.
Maybe in the meantime, as a matter of clarification, indeed, this language change for the pleadings in the Court of Appeal was a practical arrangement.
Yeah.
So, of course, the party have to consent to it, but it seems from the rules it is clear that you can have simultaneous translation. If one of the judges would not be able to understand the German language in the proceedings, there would be provided simultaneous translation. But to avoid this translation issue, of course, practical arrangements can always be achieved. And I think this was the idea here of the Court of Appeal. And most of the representatives, if not all, would of course usually agree to do it in English if their clients also agree that this is an appropriate language to be used. And it seems also to be the working language in the internationally equipped court.
Sure. As we have not seen any questions in the chat, nobody's raising their hands. Maybe I have a question. You had several cases in the, let's say, in the national system, which of course still exists, and maybe you can give a comparison between the new system, or maybe if it's more influenced by the German courts, or if you find some elements from the Belgium proceedings.
Maybe I think even if it's clear that we will hopefully evolve to one court with one culture, it's still clear that each local division still has its own traditions. I mean, say if you compare a hearing before the Dutch local division compared to the French local division or the Paris seats and the Munich division, it will be different. It will be a different kind of style of procedure. So the French local division, clearly 2 French qualified judges and 1 other judge, has a more French approach, being listen to the parties, not asking too many questions, whereas the Dutch local division and also the German local division seem to be far more interactive. So that's a difference in style, in tradition, I would say, which is normal and expecting in this kind of cases that each judge takes its own traditions with him or her. So that's something that's still visible, but we also see from the decisions of the Court of Appeal, and personally I think also from the judges themselves, they clearly want to make a new court. So
Yes.
So that's clear that they want to make it one new court, and they are really open to have input from all parties to how to make it one unified, literally, patent court.
Yeah, I mean, we are not too surprised with regard to, for example, claim construction issues and other legal issues, how the UPC addresses those questions starting from the German legal perspective, but the conduction of the proceedings as well as of the hearing is of course significantly different. As you know, in the German courts, especially in the infringement courts, we are used to be introduced by a preliminary remark which reflects the preliminary opinion of the court, so that the parties can focus on specific aspects of the case during the discussion. And it seems to be agreed amongst the UPC local divisions as well as with the Court of Appeal that this preliminary remark is usually not applied, leaving or guiding the parties more by questions interrogated or posed during the proceedings. And the other thing I would like to mention is the strict timeline of the proceedings. This is a center pillar of the court system, that they apply these deadlines very strictly, and requests for extension are usually rejected, at least if the parties had sufficient access to the information which needs to be taken into account for their submissions. And so only in cases where confidential information was not disclosed in time, they may be able to obtain extension. And this extension usually does not exceed the amount of time which is usually granted, for example, for filing a statement of defense and so on and so forth. So the right to be heard is strictly watched, of course, but extensions are relatively seldomly granted.
Mm-hmm. Yeah. Okay, thanks. I see that we now have a question in the chat. I will read it out loud. As I understand it, the UPC might be less inclined to wait for the outcome of opposition procedures. Thus, there is a higher risk of misalignment between the UPC and the EPO systems. Would you agree on this?
I think that's true. Like Roland just said, timelines are strictly enforced, let's say, by the UPC, and it's clear that the goal of all judges is to have a decision on the merits within 1 year. That is the clear goal. Knowing that, for instance, in EPO opposition proceedings, nothing will happen during the first 9 months during the opposition procedure. Even if you file your opposition documents immediately after grant of the patent, usually they wait, that's my experience at least, until this 9 period is over to even start. If you do it at the same time with UPC, you could already have a hearing scheduled, and a few months later you would have a decision. So let's say that you have a decision of the UPC, whereas the EPO proceedings merely have started in practice. So yes, I think there is a risk that there will be different decisions, and I think that has all to do with timelines, which EPO has clearly different guidelines in this regard.
I agree that there could be such misalignment in the timelines. We have not seen it in practice so far, but of course the UPC could wait for the opposition division to decide on such an opposition if the hearing in the opposition division is very close to the hearing at the UPC. Whether it will be done in the future, I'm not sure. That remains to be seen. This is the temporal aspect, and we also have a material aspect, because what happens, for example, if the UPC revokes a patent in the UPC member states, and the opposition division later on upholds this patent, maybe in a more restricted way, with effect not only in the UPC member states but also in further EPC member states. And I think this has not yet been clarified, at least definitely not by the courts, but even looking at the statutes, it is not clear how the decisions would have to be outweighed against each other. Will, for example, the UPC only, that's clear, only on the territory of the UPC member states, but does this leave room for the EPO opposition decision to take effect in the other EPC member states, and to what extent? I think that is some discussion which remains to be solved in the future.
Okay. Yeah, I think the next question is also a little bit related to this topic. It's currently the duration of proceedings before the EPC is rather short, at least in comparison to national proceedings. Mm-hmm. And do you think that this brevity of proceedings will be maintained, or will the UPC proceedings become longer once the court's workload increases?
We never should underestimate practical necessities, and we have seen just with a view to the caseload in the UPC that the UPC has taken some more judges, legally qualified judges as well as technically qualified judges, as they need further men or women power to maintain this system with this relatively high speed. It is definitely a target to maintain this, but whether it can be maintained from a practical point of view, we have to see. I cannot tell. It's hard to some extent, also for the lawyers.
Yeah, the only difference maybe is that UPC is a court funded by the users. So that's the difference with the state system. So if the users increase, let's say, there will be more funding. So in theory, there will be more judges. So it could be more aligned compared to state courts where there is not this automatic increase of judges if the cases increase. That could be the only difference I can think of, but I totally agree with what you said. That
they want to maintain the high quality, which is of course a restricted feature again.
Yeah. Okay, thank you. So, and a third question also here in the chat. Do you think that the development of the EPO's case law on the role of the description in claim interpretation, irrespective of the existence of unclarities in the claims, could have an impact on the development of the UPC's case law on this matter? So,
well, I think the principal guidelines defined by Article 69 and the protocol on the interpretation of this article are conclusive, and I don't see exactly here where EPO case law should come then further into play. This should also be in line, of course, with Article 69, and this means that they all have to agree that they agree on this point.
This is maybe also related to the adaptation of the description.
With the adaptation of the description.
Which, or I could imagine, because this is something we patent attorneys are confronted with often. So if you amend something and write it's not according to the invention anymore, maybe will this be handled like it is dealt now with at the national courts? I think in Germany they will read the patent as a whole, more or less.
Yes,
I would say.
That's what the UPC also has confirmed, that they take it into account as a whole. Yeah. Mm-hmm.
Okay, I see no more questions in the chat and no raised hands. So I have to thank you again. It was really nice having you here. And then I would close the webinar of today. Thank you very much.
Thank you.
Thank you for joining. Thank you for having us.
You're welcome.